So if you're Donald Trump, this is probably not the news you wanted to hear today. The January 6th committee has just announced that it's formally subpoenaed Trump to testify. The subpoena requests both documents by November 4th and his testimony at a deposition on November 14th. The committee released a lengthy statement, and while I won't read the whole thing, there are a few sections that are especially relevant. It says, "The Select Committee unanimously directed the issuance of a subpoena seeking your testimony and relevant documents in your possession. The subpoena calls for testimony regarding your dealings with multiple individuals who have now themselves invoked their Fifth Amendment privilege against self-incrimination regarding their communications with you, including Roger Stone, Lieutenant General Michael Flynn, John Eastman, Jeffrey Clark, and Kelly Ward. These Fifth Amendment assertions, made by persons with whom you interacted, related directly to you and your conduct. They provide specific examples where your truthful testimony under oath will be important." It goes on to say, "We recognize that a subpoena to a former president is a significant and historic action. We do not take this action lightly. But as you will likely know, you would not be the first former president to testify before Congress or to receive a congressional subpoena. Former presidents John Quincy Adams, John Tyler, Theodore Roosevelt, William Howard Taft, Herbert Hoover, Harry Truman, and Gerald Ford each testified before Congress after they left office. President Roosevelt explained during his congressional testimony, an ex-president is merely a citizen of the United States just like any other citizen, and it is his plain duty to try and help this committee or respond to its invitation. This subpoena hereby orders the production of relevant documentary material as set forth on the attached schedule by November 4th, 2022, followed by your participation in one or more days of deposition testimony beginning on or about November 14th, 2022, and continuing on subsequent days as necessary. The deposition will be under oath and will be led by the professional staff of the Select Committee, including multiple former federal prosecutors as well as members. As with all witnesses who are required to appear before the Select Committee, you may raise any relevant privilege objections to specific questions asked during your deposition. If, like other witnesses identified above, you intend to invoke the Fifth Amendment rights against self-incrimination for your testimony, please so inform the Select Committee promptly." Now, I should note that the likelihood that Trump actually shows up to testify isn't good. Remember, this is a person who already doesn't believe that the law applies to him. Add that to the fact that he denies the legitimacy of the January 6th committee, and it would take a small miracle to get him to appear. So in a situation where Trump refuses to comply with the subpoena, we can look to recent history to see what will happen next. Here's former federal prosecutor Glenn Kirshner during our recent interview to explain Trump's possible next steps.
His options are to defy the subpoena, which I fully expect he will do. And then the ball is in the J6 committee's court. They can do a couple of things. One, they can vote to hold him in contempt and make a criminal referral to the Department of Justice for a contempt of Congress charge. We know they've done that before, and it's met with mixed results, right? They did that for Steve Bannon and Peter Navarro, both of whom were indicted by the Department of Justice. They did it for Mark Meadows and Dan Scavino, neither of whom were indicted by the Department of Justice, which I find a little bit offensive because the co-equal branch of government, Congress, was a victim of the crime, the contempt, and yet for whatever reason, DOJ sort of turned up its nose, at least thus far, at the prospect of charging those other two men for committing precisely the same crime that Bannon and Navarro committed. So they can do that, though I suspect that is less likely than their second option, which is to pursue civil contempt in court. What that looks like is they will file suit in court to enforce their subpoena. And that will put Donald Trump in a position where he'll have to go to court. He will have to respond. In my opinion, he will absolutely lose the court battle, and then a judge will order him to testify. If he defies the judge's order to testify, as opposed to just defying the subpoena to testify, a judge can actually order that he be detained until he purged the contempt and appear and testifies. Now, what will he do if he is ordered to testify? We already know, Brian, we will now all be back on the hamster wheel of endless appeals. Although at least the courts seem to be expediting the court hearings and they're not letting Donald Trump run out the clock. And of course, the Supreme Court just rejected his attempt to pull the court into the Mar-a-Lago documents debacle. So right now, I think at the moment, things are looking up a little bit on the justice front.
As Glenn explained, the House has voted 4 times to hold the Trump allies who also refused to comply with subpoenas in contempt of Congress. Those referrals were then sent to the Justice Department. 2 of those, Steve Bannon and Peter Navarro, were indicted, and just today, Bannon was sentenced to 4 months in prison and a $6,500 fine, which is almost insultingly insufficient, but I suppose in a country where we generally expect zero accountability whatsoever for rich, white, politically connected men, it's better than nothing at all. The other two Trump allies who ignored subpoenas, Mark Meadows and Dan Scavino, were not charged by the DOJ. And in terms of why the DOJ would charge Bannon and Navarro, but not Meadows and Scavino, here's Glenn Kirshner again. Can you just expand on why the Justice Department would choose to indict someone like Steve Bannon and yet refuse to indict someone like Mark Meadows?
One of three reasons. Either they believe Mark Meadows is so close to the president, a former chief of staff, that they have some sort of privilege concerns. They don't want to go that high up on the food chain and charge somebody with contempt when that person says, look, I actually have some viable privileges that I could raise. That may be one reason. A second reason is they may be looking to roll him into a far larger and more significant indictment, like a conspiracy to defraud or commit offenses against the United States. That's what I would be doing if I were a prosecutor. They don't want to piecemeal a criminal prosecution against a guy like Mark Meadows, so they wouldn't want to jump out and just indict him on what is a misdemeanor charge of contempt of Congress. They want to wait and roll it into a larger conspiracy indictment. And of course, the third possibility is that Mark Meadows is cooperating. Because if he's cooperating, there is no need to bring an early charge against him. So those are the three possibilities. I don't know. I think it's a 33 1/3 proposition for each.
Now, as for Trump's response, he was unsurprisingly hostile to the subpoena, writing, "Why didn't the Unselect Committee ask me to testify months ago? Why did they wait until the very end, the final moments of their last meeting? Because the committee is a total bust that has only served to further divide our country, which, by the way, is doing very badly. A laughingstock all over the world?" So Trump would have definitely, totally been willing to testify, but his only beef is that they waited too long. Got it. So I'm not going to lie and pretend that we're not in for a long process of delays and appeals by the Trump team, because that's exactly what Trump has always done, and that's exactly what he's going to do here. With that said, it won't lighten his legal load. He's still contending with the E. Jean Carroll defamation case. He's contending with the Mar-a-Lago stolen documents case. He's contending with the New York Attorney General civil case regarding the Trump Organization. He's contending with the Alvin Bragg criminal case on the same matter. He's contending with the Fulton County DA's case over pressuring Georgia's Secretary of State Brad Raffensperger to find 11,780 votes that didn't exist. So he can delay this litigation all he wants. He isn't going to make it go away. Before you go, if you enjoyed this video and want to see more, please make sure to subscribe to my channel. You can click the thumbnail right here on this screen. And if you want to support my work even further, the best way is to subscribe to my podcast, No Lie with Brian Tyler Cohen. There you can check out my interviews with major players in the world of politics, including President Biden, Vice President Kamala Harris, Pete Buttigieg, Elizabeth Warren, Katie Porter, Jamie Raskin, and so many more. Plus other interviews that live exclusively on the podcast. That link is also right here on this screen, or just search No Lie with Brian Tyler Cohen wherever you listen to podcasts.